The Honorable Chief Justice and Associate Justices of the Supreme Court.
The House will come to order.
The Senate will come to order.
I will forgo my 10 pages of testimony because of the late hour, and just tell you basically what this bill does. This bill seeks to increase the jurisdictional limit for small claims court from $5,000 to $10,000 for natural persons and corporations. The bill would also increase the filing fee for small claims cases over $5,000 to $15. Basically, as I see it, this is a bill to help the little guy. People that go to small claims court are people that are the small business people, the constituents of ours, who really can't afford the average cost of an attorney in our area, the $375 per hour, which is our average in Maryland. And so with that, I would like to turn it over to Mr. Fred Fredericks. And unless anyone has an immediate question for me, we'll wait until after the testimony.
Thank you very much. The Maryland District Court system has 107 judges, 34 locations, and 12 districts. They file 2,050,000 plus cases in 2009. 239,034 cases were between the figures of 5,000 and 10,000. This bill calls for a $15 fee increase on those cases that fall in that range, which equals $4,395,000 annually for the court system. 7 states currently have limits between $10,000 and $25,000, including 2 from neighboring states, Delaware and Pennsylvania, which are 15 and 10 respectively. The benefits that would be realized if this bill is enacted: it opens the Maryland justice system to the business arena where it is now closed. Relief for the court system as a result of 1 dispute appearance instead of 3 or 4, and quick exposure to the mediation process. It will relieve the court case backlog again, providing 1 quick resolution. It will save the court system 219,783 hours if each case was only 15 minutes. It will save the trees as a result of reducing the volume of paper that is otherwise generated. It is important to note that law firms obviously are reluctant to accept 10,000 and lower disputes. We recognize that some lawyers will object to this legislation. They will say, for example, that you need discovery in a $10,000 case. Well, if they cannot get it resolved at the first sitting, they have the right of appeal de novo. We understand their reasoning. However, there's one question that remains. Is it fair in the state of Maryland to legislate benefits for one profession at the expense of all others? What we're trying to say is that a lot of the cases can be resolved through mediation, and I think if you'll check the records I have a package here that anybody's willing to go through that a great percentage of the cases are resolved in mediation and at the courthouse without actually having a trial. This bill in no way regulates the use of attorneys if a person chooses. What I'm trying to say is, let us resolve the issues that we can without all of the attorney ease that takes place in these cases. Thank you.
Yes, thank you, Mr. Chairman. Just to echo what Fred Frederick says, I'm Gerard Murphy with the Washington Area New Auto Dealers Association, and we're in the metropolitan Washington area, obviously. I'll simply say that this particular proposal broadens the net of the successful small claims system, which we think is appropriate. It's been 8 years since it's been looked at. Back in 2003, it went from 2,500 to 5,000. We believe it's time to move it from 5 to 10. The small claims system works. It encourages resolution, uncomplicated resolution of disputes, and it has a great track record in that respect, particularly with the mediation that goes into play before you even need to get into to see the judge. We think it's a good system. We think the net ought to be expanded.
Okay. Yes, Charlie Foster.
Mr. Chairman, as a small business owner, a small business owner, I have a problem with raising this to $10,000. Let me ask you, as the auto dealer, you have a lawyer on retainer, I assume, right? Your business?
Do I have?
Now the auto dealer.
You ask me, or
yes, you.
Yeah,
yes.
Yeah, the association does.
Okay, you have a retainer. I don't have a lawyer on retainer. And when somebody comes at me as a small business owner for up to $10,000, I'm certainly going to have. It's going to cost me more money to go out and get that attorney, because I certainly don't want to have to fight somebody that I believe has deep pockets and has enough money to come after me. Then I'm going to hire the attorney. So I just have a problem with raising this. I mean, we've raised it over the years. When I was back in the 80s, or I guess it was the 80s or the 90s, I think it was $1,000 in small claims court. I could go into the small claims court and file the paperwork myself. It was 1 or 2 pieces of paper. I could get the service done. Then it went up to $5,000. I'm reading back in Delegate 93. Is that what you? Or 2003. And now we want to double it to 10,000. And I just see it as I see it says it's for the small business, but it may be for the bigger small businesses. But as a small business owner that I am, that does a couple $100,000 worth of business a year, I just see it as a burden, and it would cause me to go out and hire an attorney. So I just want to let you know that it is a problem for me.
Well, just to set the record straight, I represent the association.
I understand that, but
I'm not the auto dealer.
But the auto dealer does have has a lawyer on file.
I don't believe you do have a lawyer on retainer.
I do not. I would like to speak to that issue. I think that you should be able to represent yourself up to $10,000 in your business. You should not have to go out and hire a lawyer if you want to sue somebody or somebody sues you. You should have the right to tell your story to the judge, and that's really what we're talking about, trying to resolve the issues without the expense and all the paperwork that normally goes through. So I think that I'm in agreement with you. I think that you should be allowed to do that up to $10,000.
But as a micro small business owner, the normal mom and pop shops that, I mean, when somebody's suing you for up to $10,000, I mean, that's a huge amount of money. It's worth the $1,000 or $1,500 to go out and get an attorney. That I'm going to have to get an attorney. I mean, when I'm looking at that kind of well, I'm not vested in the law like Delegate Simmons is. I'd have to go out and hire Delegate Simmons to represent me in a court of law. He might be a little expensive for me, but I just have to. I guess we'll just have to agree to disagree. Like I said, as a small business owner, I just think that when you're raising it, doubling it up to $10,000, I get this notice in the mail that somebody's suing me for $9,500. The first thing I'm doing is going out and looking for a lawyer. I mean, if it's under $5,000, I think I can handle that a little bit better. But when you're doubling it up to $10,000, I just see it as a problem. So I guess we'll just have to agree to disagree.
Let me also say, as a small business owner, when my husband passed away, I took his business, and I knew nothing about it. And when I had to go after someone in that business, for me to hire an attorney was very difficult at the time. And, when I had vendors that were problematic and I had to go to court, small claims court was a very easy avenue for me to pursue in my small business. Now, that being said, there are a lot of people out there that were in my situation and understand, it as a single proprietor, I didn't have the luxury of that, so it makes a huge difference. But, I also understand that it is complicated, but I think that, there are people that can go through that complicated process. And I think that it's just something that should and could be done right now.
Thank you.
You do have all the rights to go retain counsel if you want to do that.
I understand that.
And the only thing this does is give people the option of not having to do that.
And I just, my problem is when you raise it to that threshold of getting up towards $10,000, you're almost obligated as a business owner to go out and, to hire an attorney and we were in the same business actually, Delegate Frush, in the embroidery business, the screen printing business. And I did file a lot of small claims, people that didn't pay their bills. And they were resolved right away, when it's a small amount of money. But when you're talking about $10,000, I'm sure they're going to hire an attorney, which is then going to go out and force me to hire an attorney. And I just think by raising that just complicates it. So, again, we probably will have to agree to disagree.
Thank you, Mr. Chair. And for the record, I'd hire you, Mr. Chairman. And Delegate Frosch.
Yes.
Do you know approximately how many cases this would divert back to the district court that are currently filed?
No, I don't have that statistic, but I will get it for you.
Thank you.
Is it informal proof or not informal proof between 5 and 10,000 if we pass this bill?
Pardon me, I'm sorry.
Informal proof.
I don't know.
I mean, in the small claims, you used to be able to go in with informal proof. Without
I'm not an attorney, and I don't know.
It's my understanding that by moving it to $10,000, it has the same rules. It's a small claims court, and the judge is the one, if you're not satisfied with the judge's opinion, without a lawyer, you can appeal de novo in the circuit court. So the district court is really set up to resolve issues at that level, and they do a pretty good job.
They do.
The mediation process probably takes care of 30% of the cases that are filed. And I say that any business, regardless what its size is, should be able to tell their story to the judge up to $10,000.
Okay.
The threshold hadn't been moved in 8 years.
Any other questions? All right, thank you very much. Now let's hear from the opposition.
Mr. Chairman, if I could be excused, I have a bill pending in another committee.